The hook is U.S. entry getting harder in 2026? A valid U.S. visa used to feel like security. If it was stamped in your passport, you felt protected. You felt like you had done everything right, and nothing could stop you at the border. But in 2026, that assumption is being seriously challenged. A recent case involving a foreign tourist with a completely valid visa who was detained after arrival has raised major questions about how entry decisions are actually being made, and whether the level of scrutiny at U.S. ports of entry is quietly but significantly increasing. This is about lawful travelers. Before we go any further, let's be clear about what we're talking about here. This is not about undocumented crossings. This is not about people trying to sneak across borders or overstay without permission. This is about lawful travelers, people who went through the proper process, applied for a visa through the right channels, got approved, and still found themselves detained upon arrival. That's what makes this conversation so important. If it can happen to someone with a valid visa and a legitimate purpose, every international traveler needs to understand how the system actually works. A visa is not a guarantee of entry. Here is the first and most critical thing every traveler needs to understand. A visa is not a guarantee of entry. Many people don't realize this. They assume that once the visa is stamped in their passport, they're in. But that's not how U.S. immigration law works. A visa gives you permission to travel to a U.S. port of entry and request admission. That's it. The actual decision of whether you are allowed into the country is made not by the consulate that issued your visa, but by the Customs and Border Protection officer standing in front of you when you land. The power of the CBP officer. That CBP officer at the port of entry has full discretionary authority over what happens to you. They can admit you without any issue. They can refer you to secondary inspection for further questioning. They can cancel your visa on the spot. They can place you in expedited removal, or they can detain you pending a more thorough review of your case. This power has always existed. It is written into immigration law. What appears to be changing in 2026 is not the existence of this authority, but how frequently and how aggressively it is being exercised against travelers who believed their paperwork was in order. Why would a valid visa holder be detained? So why would someone with a perfectly valid visa end up detained? The answer is that officers are not just looking at your documents, they're looking at patterns. Your travel history, your answers to their questions, your online presence, and how all of those things fit together. A visa being valid doesn't mean every other element of your situation is clean. Officers are trained to look beyond the stamp in your passport and assess whether your overall profile raises any concerns about your true intentions for entering the United States. Red flag 1. Suspected overstay risk. One of the most common triggers for increased scrutiny is a suspected overstay risk. If your travel history shows a pattern of long stays in the United States, or if you've been entering back-to-back multiple times within short intervals, officers may start to question whether you are effectively living in the country on a tourist visa. Tourist visas are not designed for extended or permanent stays. If your travel pattern looks more like residency than tourism, that is going to raise serious questions at the port of entry, regardless of how many times you've entered successfully before. Red flag 2. Suspected unauthorized work. Another major trigger is suspected unauthorized work. If you're traveling on a B1 or B2 visa, which covers business visitors and tourists, and your answers about your plans sound vague, inconsistent, or heavily business-oriented, scrutiny increases significantly. Officers are trained to identify travelers who may be working in the U.S. without authorization. Even if you're just attending meetings or doing remote work for a foreign employer, the way you describe your activities matters enormously. Saying the wrong thing or being unclear about what you're actually doing in the country can escalate a routine entry into a serious problem. Red flag 3. Misrepresentation concerns. A third red flag is misrepresentation, when what you say at the airport doesn't align with your prior visa application, your travel history, or your social media presence. Officers have access to more information than most travelers realize. If you stated one thing on your visa application and your Instagram or LinkedIn tells a different story, that inconsistency will be noticed. Social media has become a routine part of immigration screening. If your online presence suggests you have ties to the U.S. that contradict a tourist intent, or that you've been working or living there in ways inconsistent with your visa, that creates a serious credibility problem. Red flag 4. Immigrant intent issues. Another area of concern involves pending immigration intent. If you have an immigrant petition pending, meaning someone is in the process of sponsoring you for a green card, traveling on a non-immigrant visa like a tourist visa becomes complicated. Officers may suspect that your real intention is to enter the country and adjust your status to permanent resident, rather than return home as a tourist is expected to do. This is called preconceived intent, and it can be grounds for denial of entry. If you're in this situation, you need to understand exactly how it affects your ability to travel before you board that plane. Red flag 5. Contradictory or incomplete answers. The fifth common trigger is something that can happen to anyone: contradictory or incomplete answers during questioning. Sometimes a detention isn't driven by a suspicious travel history or a complex immigration situation. Sometimes it simply comes down to how a traveler communicates under pressure. If you change your answers mid-conversation, if you seem nervous and provide unclear responses, or if your story doesn't hold together under follow-up questions, that raises concern. Officers are trained interviewers. They notice hesitation, inconsistency, and over-explanation. Preparation and clarity in your responses matter more than many travelers realize. What is secondary inspection? Secondary inspection is something a lot of travelers have never heard of until they're sent there. It's an additional level of screening that happens after your initial encounter with a CBP officer at the port of entry. Being referred to secondary inspection does not automatically mean something is seriously wrong. Many travelers go through it briefly and are admitted without issue. But during secondary inspection, your phone may be reviewed, your luggage may be searched, questions become significantly more detailed, your full travel history is examined closely, and notes from any previous U.S. entries are carefully reviewed. It's a much more thorough process, and if inconsistencies surface there, things can escalate quickly. Is this becoming more common in 2026? There has been no official announcement saying that the U.S. is now detaining more tourists. Enforcement environment changes rarely come with press conferences or policy statements that the public can point to. But when immigration agencies operate under stricter internal guidance, what you see in practice is tighter admissibility interpretations, more aggressive fraud screening, and less tolerance for any ambiguity around a traveler's intent. When publicized cases surface involving legal visa holders being detained, it signals clearly that discretionary enforcement is active and being exercised. This is not a change in the law. It is a change in the enforcement environment, and that distinction matters enormously. Who should be paying attention? This situation doesn't mean every tourist is at risk. The majority of travelers continue to enter the United States without any issue at all. But certain groups should be paying especially close attention right now. If you spend long periods in the U.S. each year, if you enter multiple times within short intervals, if you previously overstayed even briefly, if you have pending immigration petitions or sponsorships, or if your online presence could be interpreted as contradicting a tourist intent, you are in a category where the margin for error is shrinking. These are the profiles that are drawing increased attention at ports of entry in 2026. The social media factor. One thing that surprises many travelers is how much their online activity can affect their entry. If you claim to be visiting family on a tourist visa, but your social media publicly promotes your freelance business, your US-based clients, or your professional activities in America, that mismatch can raise serious questions. CBP officers can and do review publicly available online information: your Instagram, your LinkedIn profile, your website. All of it can be checked. If your digital footprint tells a story that contradicts what you're saying at the border, that inconsistency becomes a problem. Intent consistency across your documents, your answers, and your online presence is absolutely critical. What this does not mean. Let's be completely clear about what this conversation is not saying. There is no confirmed nationwide policy revoking tourist visas automatically. There is no announcement eliminating B1 or B2 travel. There is no blanket ban on lawful international visitors coming to the United States. The vast majority of travelers with clean travel histories, consistent intent, and straightforward purposes continue to enter without any problems whatsoever. But enforcement visibility increases when edge cases surface publicly. And when those edge cases make headlines, it reminds everyone that the discretionary authority CBP holds is real, it is being used, and it does not require a policy change to affect you. Practical step 1. Be clear about your purpose. So what can you actually do to protect yourself if you're planning to travel to the US in 2026? The first and most important step is being completely clear about your purpose for traveling. Your reason for the trip must align precisely with your visa category. If you're on a tourist visa, you should be traveling as a tourist. If you're on a business visa, your activities should fall within what that visa permits. Know before you arrive exactly what you're going to say when asked why you're entering the country, and make sure that answer is honest, consistent, and easy to explain without needing to over-elaborate. Practical step 2. Carry supporting documents. The second practical step is keeping supporting documents easily accessible when you travel. A return ticket showing you plan to leave. Hotel or accommodation details confirming where you're staying. An employer letter if you're employed abroad and need to demonstrate ties to your home country. Financial documents showing you can support yourself during the visit. These items serve one purpose: they reduce ambiguity. When an officer can see clear, documented evidence that you have a life to return to and a legitimate reason for your visit, there is simply less room for suspicion to take hold. Preparation signals seriousness and legitimacy. Practical steps 3, 4, and 5. There are 3 more steps worth covering. First, if you have any immigrant petitions pending, understand how that affects your non-immigrant intent before you travel, and ideally consult an immigration attorney. Second, avoid patterns of long back-to-back stays that could make your travel look more like residency than tourism. And third, when answering questions at the port of entry, be direct. Answer what's asked. Don't over-explain, don't volunteer information that wasn't requested, and don't change your answers mid-conversation. Over-explaining can come across as rehearsed or defensive, which ironically raises more suspicion than a calm, straightforward answer ever would. The bigger picture. What we are likely witnessing in 2026 is not random or arbitrary enforcement. It is a recalibration. Immigration agencies historically move in cycles. Periods of more relaxed interpretation are followed by stricter discretionary enforcement, which is then followed by legal challenges and eventual clarification. Right now, the trend appears to be moving towards stricter port of entry screening. That does not mean panic. It does not mean the system is broken or that lawful travel has become impossible. It means awareness. For travelers with clean histories and clear intent, entry remains routine. But for those operating anywhere near the gray areas, the margin for error is visibly shrinking. The final takeaway and CTA. Here's the final takeaway. A visa is permission to request entry into the United States. It is not a guarantee of admission. Detention of a valid visa holder is rare, but it is not impossible. And when these cases surface publicly, they send a clear signal that discretionary authority is being actively used. Travel smart. Make sure your documentation aligns with your intent. Understand what your travel history looks like from an officer's perspective. And if your situation involves any complexity, pending petitions, long stays, or business activities, take the time to get proper advice before you travel. In 2026, entry decisions are receiving closer attention than they have in years,